Well, that breaking news right now at 10 o'clock out of Western North Carolina. A 16-year-old girl arrested for the alleged murders of both of her parents and her grandmother. An adult man has also been charged in their death.
Good evening at 6 o'clock. The man charged with murdering 3 people in Fairview goes before a Tennessee judge today and indicates he may not fight extradition.
Devan Loving and a 16-year-old are charged with killing Travis and Kimberly Grant and Travis Grant's mother, Sharon Grant, at their home in Fairview.
Thursday evening, May 7th, 2026. Fairview, North Carolina. A quiet residential pocket of Buncombe County, set in the wooded hills southeast of Asheville, just past 7 in the evening. The kind of evening when porch lights start coming on, one by one, along Ashworth Drive. Patrol deputies from the Buncombe County Sheriff's Office pulled into the driveway at number 18. They had been there before. Twice that week, in fact. Monday, Wednesday. Each time they had knocked. Each time they had left. This was the third call. A relative had phoned it in. Friends and family had not heard from the people inside in days. Something was wrong, and the relative could feel it before they could prove it. The deputies approached the house. This time they had what they needed to go in. What they found inside would not leave them. 3 people. 3 gunshot wounds. The investigation that began in that hallway would, within 36 hours, stretch across state lines, involve 4 separate agencies, and come to rest in a hotel parking lot just over the Tennessee border. Travis Eugene Grant was 41 years old. His wife, Kimberly, was 42. His mother, Sharon, was 66. And someone who had lived in that house was missing. This is the story of how a welfare check at 18 Ashworth Drive, the third one in 4 days, uncovered a triple homicide that police had now twice walked away from. And it is the story of the 16-year-old who deputies say helped end 3 lives in her own home. Welcome back to Fatal Casebook. Tonight's case is a story about a door that police could not legally open and what was waiting on the other side of it. About a household that had been silent for days while officers stood on its porch. About a 16-year-old daughter, a 28-year-old boyfriend, and 3 family members no one would see again. Take a moment to subscribe and turn on notifications. And now let's begin. To understand what happened at 18 Ashworth Drive, you need to know who lived there. Travis Eugene Grant, 41 years old, husband, father, son. He shared the house on Ashworth Drive with his wife, Kimberly Michelle Grant, 42, and his mother, Sharon Harwood Grant, who at 66 was the household's oldest resident. 3 generations of one family under one roof. Their daughter, Travis and Kimberly's only publicly identified child, was 16. Her name was Star.
They treated me like I was their own, and it felt so weird that to expect my neighbor to do all that.
Describe the Grants as the kind of neighbors you waved at as you drove past. A boring street. A family who waved at the people driving by. 3 generations sharing a home. A daughter who lived there too. That is what 18 Ashworth Drive was, the day before the welfare checks began. That is what it was before someone stopped answering the phone. Fairview is a community in unincorporated Buncombe County, set in the wooded ridges southeast of Asheville. It is the kind of place people move to for the quiet, narrow roads, scattered houses, neighbors who know each other's vehicles. The kind of place where, as Andy Bennett put it, nothing is supposed to happen. The county that contains it is no stranger to violent crime. In 2017, a man named Pierre Griffin III pleaded guilty to a triple homicide in Buncombe County connected to a drug deal. 3 young people whose bodies were found in apartments and pulled from the French Broad River. That case ended in a life sentence. It was, until this week, the most cited triple homicide in the county's recent history. But Fairview itself does not carry that history. Fairview is the kind of street the local paper covers for charity drives and zoning meetings. There is a second piece of context that matters here, and it is not geographic. It is legal. In North Carolina, a 16-year-old charged with a Class A felony, first-degree murder, is automatically prosecuted as an adult. There is no juvenile transfer hearing. There is no judicial discretion. The state's framework treats first-degree murder as a category of offense so severe that the question of the defendant's age is, for charging purposes, set aside. The Class A designation also means that, on conviction, the defendant faces only two possible sentences: life imprisonment without the possibility of parole or the death penalty. The U.S. Supreme Court's 2005 decision in Roper v. Simmons removed the death penalty from the table for crimes committed under the age of 18. That leaves life without parole as the maximum sentence available to the state, should this case go to trial and end in conviction. A 16-year-old. A first-degree murder charge. 3 counts. 1 conspiracy charge. A co-defendant 12 years older. That is the legal architecture this case is now sitting inside. 2 people stand accused. The Buncombe County Sheriff's Office identifies them as Star Grant, 16, of Fairview, and Devan Oneal Loving, 28, also a resident of Buncombe County. Loving's name surfaces in court records before this week. In March 2018, he was charged with simple assault. The charge was dropped by the district attorney. No conviction followed. According to court records reviewed by reporters at the time of this video, that 2018 entry is the only prior law enforcement contact on his record that has been made public. No additional convictions, weapons charges, or felony entries have been reported. Star Grant has no comparable record in public reporting. She is 16 years old. Until 7:15 p.m. on Thursday, May 7th, she was, to anyone outside her household, a teenage girl who lived in Fairview with her parents and grandmother. The sheriff's office has confirmed she lived at 18 Ashworth Drive. She is the daughter of Travis and Kimberly. She is the granddaughter of Sharon. The age gap between the 2 suspects is 12 years. How they came to know one another, when they met, what the nature of their relationship was, none of this has been disclosed in public reporting. The sheriff's office, when asked at the May 8th press conference about the relationship between the two, said only that its nature is, quote, not known at this time. This is one of the central unanswered questions in this case. It is the question investigators are working to answer right now. It is the question a defense team will inevitably contest. And it is the question that, when answered, will reshape this story. For now, what is documented is this. A 16-year-old and a 28-year-old, both Buncombe County residents, both arrested on 3 counts of first-degree murder and 1 count of felony conspiracy. Both in custody. In Tennessee. Until court documents start opening, that is all we know. Most true crime relationship maps are reconstructed years after the fact, from court testimony, from text message exhibits, from witness statements offered up under oath. Star was a 16-year-old living at home with her parents and her grandmother. Her co-defendant is a 28-year-old man who lived elsewhere in Buncombe County. The age gap alone places the relationship in a category that requires explanation. The fact that they fled the state together, to a hotel room in a tourist town across the Tennessee line, places it in a category that requires investigation. What investigators are working to determine, right now, is the question every prosecutor and every defense attorney will need to answer in court. How did these 2 people become co-defendants? The hidden layer in most true crime cases is what the victims did not know. The affair, the insurance policy, the search history, the file in the social services drawer that no one ever escalated. In this case, the hidden layer is, for now, the entire motive. Why 3 people are dead in a house in Fairview is, at the time of this video, the central undisclosed fact of the investigation. The sheriff's office has filed conspiracy charges, which is itself a statement. Prosecutors believe these 2 suspects acted together, with intent, and with planning. But the public record contained. By Wednesday, the silence had become loud enough that someone called the sheriff. By Thursday, 3 days of silence had become permanent. The Buncombe County Sheriff's Office has confirmed 3 things about what happened inside 18 Ashworth Drive. The first is method. Travis Eugene Grant, Kimberly Michelle Grant, and Sharon Harwood Grant all died of gunshot wounds. The Sheriff's Office and the State Bureau of Investigation have stated this publicly. The specific weapon, the number of shots fired, the order of events inside the house, none of this has been released. The second is timing. WSMV reporting from Friday, May 8th, citing deputies, established that the 3 victims, quote, had been deceased for a few days before they were discovered Thursday evening. That places the events somewhere between the previous weekend and the early part of the week. The third is who is alleged to have done it. The sheriff's office has charged Star Grant and Devan Loving jointly with 3 counts of first-degree murder and 1 count of felony conspiracy to commit murder. Conspiracy is the legal claim that 2 or more people agreed to commit a crime together. Filing it is a statement of theory. Prosecutors believe this was not a single perpetrator's act, and they believe it was not impulsive. What it is not yet, at the time of this video, is a proven case. No trial has occurred. No evidence has been entered into the public record. No formal defense has been filed. The presumption of innocence applies to both defendants until proceedings produce a verdict. What investigators have already established is enough to charge. What they have not yet shown is enough to convict. The space between those 2 thresholds is where this case is now sitting, and it is where it will sit for months to come. Whatever happened at 18 Ashworth Drive, 2 people were not in that house when deputies arrived on Thursday evening. By the time the welfare check produced an answer, Star Grant and Devan Loving were already across the Tennessee state line. Gatlinburg, Tennessee, sits in the foothills of the Great Smoky Mountains, just over the North Carolina border. It is a tourist town, a place of cabins, theme parks, and pancake houses. In the first week of May, it is busy with the start of the season. Crowded enough that 2 people, one of them a 16-year-old, would not draw a second look from the staff at any one of its hundreds of motels. According to reporting from local outlets, including 828 News Now and Fox Carolina, the suspect's route ended at a hotel on Omby Street in Gatlinburg. What investigators do not appear to have found at the hotel was an attempt to disappear. There was no abandoned vehicle, no false names that have been reported, no concealment of the identifying information that would prevent law enforcement from confirming the match. The car they had arrived in was parked in the lot. The hotel room they were renting was registered. If the alleged plan was to leave Buncombe County and start a new chapter in Tennessee, it was a plan that did not anticipate the speed at which the Grant family would be missed, or how quickly that missed call became a multi-agency manhunt. The first welfare check at 18 Ashworth Drive happened on Monday, May 4th. A relative, friends, family, someone whose name the sheriff's office has not made public, had been trying to reach the Grants and was not getting through. They contacted the Buncombe County Sheriff's Office and asked for someone to go to the house. A welfare check, in standard police procedure across the United States, is one of the lowest stakes calls a department handles. It is a knock at the door, a look around, a conversation if anyone answers. If no one answers, and there is no specific articulable evidence of an emergency, the deputies leave a note, file the call, and move on. The Fourth Amendment to the United States Constitution prohibits warrantless entry into a private residence except in narrow circumstances. Consent, exigent circumstances, the community caretaking doctrine, or probable cause coupled with the impracticality of obtaining a warrant in time. These exceptions are narrow on purpose. On Monday, those circumstances were not met. The deputies left. On Wednesday, May 6th, a second welfare check was requested. Deputies returned to 18 Ashworth Drive. The standard the Constitution requires for warrantless entry was, again, not met. They departed without entering. At the press conference on Friday, May 8th, Sheriff's Office officials addressed this directly. Their statement, as reported by WSMV and Fox Carolina, was that on neither earlier visit did deputies have, quote, the necessary evidence of an emergency to legally force entry into the home until the third visit. That third visit was Thursday, May 7th, at approximately 7:15 p.m. Something had changed by Thursday. The relative who initiated the call had information, additional context, a longer silence, more failed attempts at contact, possibly a specific reason to escalate. Whatever it was enough to satisfy the legal threshold for entry. When deputies entered, they found 3 people. All 3 were deceased. All 3 had gunshot wounds. The State Bureau of Investigation was contacted. So was the Sheriff's Office Investigative Unit. And as they began to process the scene, one element of the household was missing. The 16-year-old who lived in the house was not there. The detectives who arrived on Thursday evening were now working two cases at once: a triple homicide and a missing teenager. In most circumstances, a missing teenager from a homicide scene is a victim, not a suspect. Until there is reason to believe otherwise, that is the working theory. The sheriff's office has not made public the precise moment that working theory shifted. What is on the record is that, by the early hours of Friday morning, investigators were no longer searching for Star Grant as a missing person. They were coordinating with the North Carolina State Bureau of Investigation, the Tennessee Bureau of Investigation, and the Gatlinburg Police Department to locate her, and the man, 28 years old, whose connection to her had become a focus of the investigation. Somewhere in the hours between 7:15 p.m. on Thursday and 8:30 a.m. on Friday, evidence emerged that turned a missing teenager into a wanted suspect. That evidence has not been disclosed publicly. It is one of the questions a defense attorney will eventually ask in court. What is documented is this: by the time the sun came up on Friday morning, deputies were no longer worried about whether Star Grant was alive. They knew where she was. They were worried about whether she would still be there when they arrived. In the early hours of Friday, May 8th, a vehicle connected to Star Grant was located in the parking lot of a hotel on Omby Street in Gatlinburg, Tennessee. The exact mechanism by which that match was made, license plate recognition, manual surveillance, a tip from a member of the public, a triangulation of cellular data, has not been publicly disclosed. What the multi-agency statement on Friday confirmed is that the location was identified and that it was confirmed before any approach was attempted. Once the vehicle was confirmed, the operation that followed was rapid. Officers from the Gatlinburg Police Department, supported by the Tennessee Bureau of Investigation, took up positions outside the hotel room registered to the suspects. The Buncombe County Sheriff's Office and the North Carolina State Bureau of Investigation, working from across the state line, were in coordination throughout. The communication structure between the four agencies, across two states, across federal information sharing protocols, was tested in compressed time. By the operational standards of interstate suspect tracking, the response was fast. By approximately 8:30 a.m. on Friday morning, the room was entered. The suspects were inside. Both were taken into custody without incident. The investigation that had begun 13 hours earlier with 3 deceased victims in a Fairview hallway now had 2 suspects in custody on the other side of the state line. The next phase of the case had begun. Star Grant and Devan Oneal Loving were taken into custody at the Gatlinburg Hotel on the morning of Friday, May 8, 2026. At a press conference held later that day, the Buncombe County Sheriff's Office announced the charges. Both suspects were charged with 3 counts of first-degree murder, 1 count for each of the 3 deceased victims. Both were also charged with 1 count each of felony conspiracy to commit murder. The Sheriff's Office confirmed that, despite Star Grant's age, she would be charged as an adult. Under North Carolina law, this is not a discretionary decision in cases involving Class A felonies. It is automatic. Devan Loving's prior record was reviewed. The 2018 simple assault charge that had been dropped at the district attorney's discretion was the only entry that surfaced in court records reviewed by reporters at the time of this video. There is no record of subsequent felony convictions or weapons charges in publicly available filings. Neither suspect has yet entered a plea. Neither has appeared before a North Carolina judge. Neither has had the opportunity to provide a public defense, because both are still in Tennessee, held pending extradition proceedings to return them to Buncombe County to face the charges. That is the narrow legal phase the case is in tonight. There is no trial yet. There will not be one for many months. Extradition between U.S. states is governed by Article 4, Section 2 of the Constitution and by the Uniform Criminal Extradition Act, which has been adopted in some form by nearly every state. The process is procedural rather than evidentiary. The receiving state, Tennessee, in this case, is not required to evaluate the strength of North Carolina's case. It is required only to confirm that the suspects are who North Carolina says they are, and that the paperwork from the originating state is in order. Extradition can be waived by the suspect, in which case it moves quickly, can be contested, in which case it moves slowly. The public record at the time of this video does not indicate whether either suspect intends to waive. Once both suspects return to Buncombe County, the case enters its standard phase. Bail hearings, initial appearances, arraignment, discovery, pretrial motions. Then, if the case is not resolved by plea, a trial. For a Class A felony with 3 counts and a co-defendant, and the additional consideration of one defendant's age, the timeline from arrest to trial is typically measured in years, not months. 12 to 24 months is a reasonable expectation. Longer is possible. In that span of time, court records will open. Search warrants will be unsealed. Forensic reports will become exhibits. Cell phone records will be produced. The motive, the sequence of events, the alleged communications between the two defendants, the question of how a 16-year-old and a 28-year-old came to be charged together, all of it will surface piece by piece in the kind of documents that turn news stories into court records. That is the case as it stands tonight. It is not finished. It has barely begun. There is one part of this case where the timeline is clear and where the documentation is complete and where the questions are ones that can be asked and answered in public in the open right now. That is the question of the welfare checks. On Monday, May 4th, deputies from the Buncombe County Sheriff's Office responded to a welfare check call at 18 Ashworth Drive. At the time of that visit, 3 people who had not been heard from for at least one full day were inside the house. Whether all 3 were already deceased at the time of that visit is a question the medical examiner will answer in the months ahead. What is established by the sheriff's office's own statements is that the victims had been deceased, quote, for a few days by the time they were discovered Thursday evening, a window of time that very likely overlaps with at least one, and possibly both, of the prior welfare checks. On Wednesday, May 6th, a second welfare check was conducted. Deputies arrived. Deputies left. The sheriff's office statement: insufficient evidence of an emergency to justify forced entry. The legal framework that produced this outcome is real, and it is not the fault of the deputies who knocked on the door. The Fourth Amendment exists for good reasons. Warrantless entry into private homes, except in genuine emergency, is a power that democracies have historically been very careful about handing to police forces. The community caretaking doctrine, the exigent circumstances exception, the probable cause with impracticality exception, these are the narrow channels through which law enforcement can override the constitutional default. But the question this case raises is not whether the law is correct in principle. It is whether the law, as applied, produces good outcomes in the cases where it matters most. 2 welfare checks were initiated by people close enough to the family to be worried. Both were closed without entry. The third welfare check, the one initiated by a relative with what appears to have been more specific information, produced the entry that uncovered 3 deceased victims. The systemic question is this: what was different on Thursday that was not present on Monday or Wednesday? Was it the information the calling relative provided? Was it the deputy's own assessment? Was it a different supervisor authorizing a different threshold? Was the second check a missed opportunity? Or was it the legally correct response to information that was not yet sufficient? These are questions the Buncombe County Sheriff's Office has not yet publicly answered. They are questions every sheriff's office in this country should be asking right now, regardless of the verdict in the criminal case. This case is not finished. There has been no trial. There has been no verdict. The 2 people arrested in a Tennessee hotel room early Friday morning are presumed innocent under U.S. law until a court of competent jurisdiction finds otherwise. The motive remains undisclosed. The relationship between the suspects remains uncharacterized. The forensic evidence remains in evidence lockers. The cell phone records remain unsealed. The text messages, if they exist, remain on devices. Travis Eugene Grant was 41. Kimberly Michelle Grant was 42. Sharon Harwood Grant was 66. The street they lived on is the kind of street where, as Andy Bennett told the Asheville Citizen-Times the day after their bodies were found, nothing ever happens. Nothing ever happens until something does. What happened to this family will be reconstructed, slowly, by people who have access to evidence the rest of us do not. By detectives, by prosecutors, by defense attorneys, by the medical examiner, by a jury eventually if the case goes that far. The story you have just heard is the story as it stands at the moment of recording, verified, sourced, and bounded by what is currently public. It is not the full story. The full story will come. When it does, this channel will return to it. In the meantime, there is one part of this case that does not need to wait for a verdict to be useful. The question of why a welfare check on Monday and a welfare check on Wednesday produced the same answer, and why the welfare check on Thursday produced a different one, is a question the Buncombe County Sheriff's Office can begin answering today. Every county in this country runs welfare checks under similar legal constraints. The protocols that produce this outcome in Fairview produce similar outcomes in thousands of other places, every week. If 3 people were already dead in that house when deputies stood on the porch the first time, and we do not know yet whether that is the case, but it is a possibility the timeline does not foreclose, then the question of what we ask of welfare checks and what evidence is sufficient to enter a home is not an abstract one. It is an operational one, and it is one that should be asked again, every time, by everyone whose job is to walk away from a closed door. If this story matters to you, if you believe the questions it raises deserve to be tracked through to their answers, subscribe to Fatal Casebook and turn on notifications. We will return to this case when court documents open. We will return to it when the motive is disclosed. We will return to it when the verdict, whenever it comes, is read.